Okay, I never say this because I really normally, for the most part, don't even care, but you really have to watch to the end of this. Like, it's. Anyways, just watch to the end, please. Normally I wouldn't give a shit, and I really don't care how long you guys watch it, because I really don't care who watches this. But this is one of those things that I want somebody who is important enough to do something about it to see in the amount of time necessary to do something about it. You know.
All right, members of the jury, welcome back. At this time, I will ask your foreperson, have you reached a verdict?
We have.
Have you reached a verdict in every case, each count?
We have.
Is every verdict unanimous?
Yes, sir.
All right, if you can hand it to the deputy, please.
Thank you, sir.
All right, cause number 2023 CR 11510A, Alejandro Flores, count one murder, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of murder as charged in count one of the indictment in cause number 2023 CR 11510A. Number two, aggravated assault, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of aggravated assault as charged in count two of the indictment in cause number 2023 CR 11510A. Number three, aggravated assault, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of aggravated assault as charged in count three of the indictment in cause number 2023 CR 11510A. Number four, deadly conduct, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of deadly conduct as charged in count four of the indictment in cause number 2023 CR 11510A. Cause number 2023 CR 11510B, count one murder for Eleazar Alejandro, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of murder as charged in count one of the indictment and cause number 2023 CR 11510B. Count two, aggravated assault, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of aggravated assault as charged in count two of the indictment in cause number 2023 CR 11510B. Count three, aggravated assault, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of aggravated assault as charged in count three of the indictment in cause number 2023 CR 11510B. Count four, deadly conduct, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of deadly conduct as charged in count four of the indictment in cause number 2023 CR 11510B. Cause number 2023 CR 11510C, Nathaniel Villalobos. Count one, aggravated assault, verdict form. We, the jury, find the defendant, Nathaniel Villalobos, not guilty of the offense of aggravated assault as charged in count one of the indictment in cause number 2023 CR 11510C. Count two, deadly conduct, verdict form. We, the jury, find the defendant, Nathaniel Villalobos, not guilty of the offense of deadly conduct as charged in count two of the indictment in cause number 2023 CR 11510C. Does either side wish to have the jury polled?
No, Judge, we don't wish to.
No, Your Honor.
All right, members of the jury, what that means, the court finds that your verdict is unanimous verdict on each verdict for each defendant. Y'all may have a seat.
Like, this may seem normal to some people, but I don't understand how you can have three people all on trial at the same time for murder and then each have an individual charge of murder, right? When only one person died. How can it's impossible for them to all be guilty, right? But it is possible for them all to be innocent. Like, it just mathematically, it's rigged. You know what I'm saying? So I just don't understand it. I can see how it's legally possible, but actually possible, it's not. But the only possibilities are that they're all innocent or one of them's guilty. You know what I mean? Now, the only reason that you would be in this situation is because a an attorney tried to slide this one by, and the other attorney didn't say anything, right? If you don't raise it as an issue, then it won't be raised, right? And for that matter, the judge would have had to allow it, meaning that if the prosecuting attorney didn't raise the issue, and the judge, you know what I mean, didn't bring it up to the attorney in court, then this is okay, right? So this tells me that the district attorney and the judge had something to do with this outcome being the way it was. With that being said, let's see what happened first with these 3 police officers, and then we'll go from there, so to speak. Anyway, this is the woman that they shot. Her name was Melissa Perez, and I actually been following this since the beginning because, anyways, I'll talk about that later. But anyway, I just want y'all to see this. This is what she looks like. She was not crazy, I don't think.
Trial of 3 former San Antonio police officers involved in the shooting death of this woman, Melissa Perez, last year.
Attorneys for both sides, as our Daniela Ibarra explains, had concerns about Judge Stephanie Boyd presiding over this case.
If you don't know who Judge Stephanie Boyd is, she is an elected judge that applies the law equally to police as she does to people, right? If you're a cop and you're in front of her, she's going to treat you just like she treats one of us, right? That's what they don't like. But they probably can't say on air or in public that we think she's biased because she's not biased. Her bias is that she's not biased. Her bias is that she treats everybody equally, right? They can't say that, right? So they have to come up with something. So the defense attorneys said something about she didn't allow the extension because he blamed some shit on his kid or something or whatever, and because of her YouTube channel.
Fourth Administrative Judge Sid Harrell making a big decision in a major case.
I cannot see where it would be fair or efficient to allow this case to go forward with Judge Boyd.
I want you to notice the name tag. He's sitting in her chair. This is her courtroom, right? Whoever this guy is. But it says right there, Judge Stephanie Boyd. Okay? Just remember that for a couple minutes. But also, too, they did raise the concern about her YouTube channel repurposing the videos for demeaning clients and demeaning the lawyers, right? And also another thing, live streaming, right?
To put me in as an attorney because I have to take care of my child.
Oh yeah, and then somehow sticking to the calendar and the date for trial was somehow a biased decision that she didn't add in the defense attorney's child's needs on top of that, right? That's part of the bias. Give me a break.
The defense also brought up the judge's YouTube channel, which live streams her court proceedings. They say video is pulled.
And they picked this one. Judge Boyd rips defense attorney apart for prioritizing vacation over trial.
Judge's YouTube channel, which live streams her court proceedings. They say video is pulled from it and repurposed to demean clients and attorneys, like Goss. While Goss was testifying about her, Boyd walked in.
Judge, I apologize. Could you step out because I don't want them to try to call you?
Sure.
What did you think about Judge Boyd walking in during the middle of the hearing?
I think it speaks for itself.
The defense.
So her walking into her own courtroom speaks for itself. It does speak for itself. It's totally normal that she would walk into her own courtroom. There's a whole bunch of people that are just occupying all the seats in her courtroom, including hers. I mean, give me a break, dude. Okay, and now listen to this fucking word salad jumble fuck of an explanation of whatever. Listen.
For itself.
The defense asked the judge to require lead prosecutor Jeff Mulliner to testify too.
With the elected judge of the 187th, it is one more issue for me to have some very significant concerns about the possibility that this works or operates along with other possible factors to make.
What is he talking about? Get to the point already.
A conviction, should there be one.
So his problem is that a judge's decisions might lead to a conviction of a police officer who murdered somebody. If he did, then that's what happens. You know what I'm saying? But I guess since that is a concern, right? Why don't we change it and give it over to an administrative judge who was appointed by the governor, right? Because that's a better idea.
Judge Harrell didn't say. Judge Harrell granting Jeff Goss believes Judge Boyd is biased against him. Judge Boyd wanted to proceed with the trial this month even though attorneys asked for more time to go through evidence and Goss was going on paternity leave.
You see how they make it sound like the reason why is because she wouldn't give them more time to go through evidence? That's not the case. This is why that she denied that. It's not because of going through evidence. It's because the attorney, Jason Goss, came up with some bullshit about his family.
And Goss was going on paternity leave.
It puts me in a position of having to advise my client, either you get me or you get your best defense.
So his testimony is you can only have your best defense, and it all hinges on my wife being pregnant, right? That's why the judge allowed this to happen, is directly because of this testimony. Okay, so that affected the outcome of where the trial is going to be for sure. Just anyways.
Mental health crisis. Chief McManus, who reviewed the body camera video today, said the officers tried to get Perez into a patrol car, but she ran back into her apartment.
I want you to see what an attempt to get her in a patrol car looks like, or sounds like.
Hey, lady, get over here.
Oh, and just another small detail. When they say ran into her apartment, they really mean walk at a consistent pace that she was walking at before into her apartment.
Hey, lady, get over here.
He even whistles at her. He says, "Hey, lady," and then does the little dog, like, come here whistle, and says, "Get over here." What the fuck? Even their own police chief says what they did was unreasonable and not in line with policy.
Hey, lady, get over here. Hey, lady, get over here.
3 San Antonio police officers have been charged with murder and suspended without pay after killing a woman armed with a hammer inside her own apartment.
The chief said to reporters tonight his officers made the wrong decision.
The shooting officers' actions were not consistent with SAPD's policy and training, and they placed themselves in a situation where they used deadly force, which was not reasonable.
Police followed Perez to her first-floor apartment, where they say she locked herself inside. An officer removes the screen to her open window. Perez hits the officer with what appears to be a glass candle.
You're gonna get shot.
Shoot me.
So they were stalking her, and now they're trying to break into her house, and she throws a candle at them.
You ain't got no warrant.
Here's a wider
That was her saying, "Y'all ain't got no warrant."
angle of the confrontation.
You ain't got no warrant. Hey, watch out.
They say Perez then swung a hammer, shattering a window. Officers then fired the deadly shots. According to police, Perez was hit at least twice. Paramedics pronounced her dead at the scene.
3 San Antonio police face murder charges after shooting a woman in her own home who appeared to be having a mental health crisis. She was supposedly armed with only a candle and a hammer.
Actually, she was unarmed because she threw the candle at the window, and then they say she used a hammer to break the window before they shot. And she was standing behind the couch. There's no way she walked up to that window, and so she threw the hammer as well. She literally had nothing in her hands, and she was behind the couch, which was like 20 feet away. And then one of the officers closed his eyes and mag dumped, and then the other two started shooting, right? This is absolutely murder, 100%. Anyways, that's my opinion.
USA Today reported that Chief William McManus and Melissa Perez said Marissa Perez was talking to fire officials outside the apartment complex at about 12:30 a.m. Friday after she was suspected of cutting the wires to a fire alarm at the apartment when an officer approached her. The officer can be heard on body camera video saying, "Hey lady, get over here," as Perez ran into her apartment. Now, Perez was speaking calmly with the firefighters, but then, of course, as police often do, when they entered the scene, they immediately escalated the situation and essentially chased her into her own home. According to New York Times, after climbing over her porch railing, an officer opened her window screen and said, "You're going to get shot," according to body camera footage released by the department.
So anyways, this is just the beginning of my point, but my point is that everybody that has viewed this and seen the shooting, and experts, everything. Everybody thinks that they're guilty of murder. Their own police chief says they didn't follow policy and that it's unreasonable what they did and basically fired them, right? And the public in general just basically believes as well, like I do, that these officers, in my opinion, were guilty of murder. The social news media believes the same thing, that they're guilty of murder. Nobody thinks these cops are not guilty, right? Nobody. And the jury found them not guilty, which, again, nobody thinks that way. The only way they could possibly be found not guilty is if the people who put them in that situation are guilty of putting them in that situation. Like, for example, like moving the trial away from her hometown, you know, like stuff like that, right? So I'm focusing on all the deciding factors of how the trial got to be where it was and when it was. And those people, I think, are the ones that are guilty. Not of murder, but I mean just guilty of doing that. Guilty of putting them in a place where they could reach an outcome of not guilty when it's obvious that they're guilty. You know what I mean? So starting with the beginning, this case was in front of Judge Boyd and it got moved. So who was responsible for that? Well, that would be this guy. Judge Sid Harrell, who was apparently appointed by the governor of Texas, right? And I did some other research on him, but we'll go back to that later. Now, the reason that he made this decision was based on the testimony in open court under oath of this guy, Jason Goss. And then to sell it to the media and, you know, to have a good-looking face on camera to back it up was this guy. Nico LaHood, right? LaHood, Nico. So these three, this guy, and this guy, are the reason that trial came out the way it did, right? It ended up them being not guilty when they're guilty, in my opinion. So it's 4:30 in the morning on January 8th, and I just got done watching the second day of trial for the Uvalde school shooting trials, right? That got moved from Uvalde to Nueces County, the county that I live in, right? It's 12 miles away from my house where the courthouse is. Anyway, here is the after day 2 interview that they got from the media, right? You're going to see some faces you hopefully recognize after watching the first half of this video.
Which is where we put an OD. Say we to talk about, or where we all agree that Adrian drove to when he thought that he was encountering the shooter or somebody with the shooter. He drove there, and that's what happened in open safety. But having this witness who has never said that before to us and only to them, that's what was shocking to us, and that does affect our trial.
Yeah, so it was a surprise. So she testifies for the first time. It's the first time we heard it. The part that was bothering to us, troubling, I think, to most people that were watching, is that she said this in the salad rack. I to hear it for the first time in trial. It was nothing that we've seen before in discovery. That she has said this before. That's trial preparation, and it's a critical issue in the case. Location is a critical issue in the case, and what you're Adrian saw or didn't see. But then the problem that's more troubling is the fact that she told them in December and they didn't know it.
Do you think this means? Do you think this is doing the Brady standard? And you can
look at the analysis needs to be made. It falls under that umbrella, and so that's what's going to be argued tomorrow. And
it's because the belief is that this could potentially clear your client this color.
Well, it's not about that. If any evidence that bolsters the government's witness or could contradict their credibility even is relevant for us.
And so I wasn't here in the beginning. So are you going to ask her in this trial?
We're camera disclosed up right now. We have to.
Is that something I would consider?
It's a remedy allowed by law, and we're not saying that we're going to take that remedy or not, or argue for that remedy or not yet.
But it is something that's possible.
The judge had that available to him.
It is what the Brady violation is, but because they don't know and why this might fit under Brady.
Well, it's exculpatory, so Brady covers exculpatory evidence, not just evidence that exonerates somebody, but could impeach a government witness to hurt their credibility. And in a case where credibility is really critical and it affects.
Okay, so the issue is her credibility here as well.
For this witness.
And they also the Michael Morton back here in Texas too, but this train in as well.
Yes, so 3914, which is also the Michael Morton Act, Article 3914 of the Texas Code of Criminal Procedure says that the prosecution has to turn over everything that they have including any statement that might be inconsistent with what a witness has said before. Obviously, what we showed is when the Rangers interviewed this witness 4 days after this happened, she never said that.
Okay, just real quick. Think of how fucking retarded this guy is, dude. If a statement is inconsistent with what somebody said before, meaning it's not the same statement, then yes, then agreed or whatever, you broke the rule. But if you didn't say something, right, you can't use the fact that somebody didn't say something or they kept silent as a reason for that to be inconsistent with what they're saying now. You know what I'm saying? Like it. These people are fucking crazy and retarded at the same time. They're crazy and stupid. So just in general and morally, that's just wrong, you know, and it's dishonest, right? But the thing is what they're talking about is she didn't tell the Texas Rangers law enforcement of this thing that she is now saying, right? So they're saying that her silence when questioned by law enforcement is the reason to call it inconsistent because it's inconsistent with what she's saying now. Because she's actually saying something, right? Anything can be inconsistent with something else if what you're saying that is inconsistency is that they didn't say it before. You know what I mean? And the fact that they're claiming that it was to an interview with law enforcement, it just implicates the Constitution. You know what I mean? That it's a Fifth Amendment right to not incriminate yourself and to remain silent. So what the fuck, bro?
What we showed is when the Rangers interviewed this witness 4 days after this happened, she never said that. And that's a pretty big deal if you saw somebody with a gun at your school matching that description. So when they said that, and that's what we were arguing, and when she testified to that, I didn't know at the time that she had told the prosecution that, and they hadn't told us. And so I didn't know if this was something she's saying for the first time on the stand, or something she said to them before, when everybody clarified and agreed and admitted on the record that it was something that they had known and not told us. That's where we have this.
Mr. Lohead, just as a...
I mean, this is not a game to us. I mean, Adrian's and the families of Uvalde, they want closure too, and they deserve to know all the truth. This is not just about Adrian, it's about everybody, it's about that community. That's what it matters. I mean, this is a big deal. And so, if we're going to go back and we're going to strategize and talk and prepare the information the judge wanted and requested from us, and we'll make our arguments tomorrow, and the judge will make his ruling.
But certainly for the families, they've been devastating. Is that right?
We're not contesting that. I think you saw that.
Yeah, but and then to have something like this today. Imagine.
But Nico, could you talk about the preparation that seems to have...
Looks to me like even this footage was altered. Like, watch his mouth and what he says. They bleep out a word.
taken place for this case? This is a huge case. This is a big mistake.
Yeah, Miss Smith, we don't know what it is yet. Miss Smith, we don't know what it is yet. Miss Smith, we don't know what it is yet.
This is a big mistake.
Yeah, Miss Smith, we don't know what it is yet. Okay, but the judge will make that determination. What I'm saying is it shouldn't happen. Let's put it that way. And yes, the government is prepared. We have put a lot of preparation in. Families have been waiting. Adrian has been waiting, and everyone's life is to unfold. And so it's a big deal. And you have to Infinite.
What decisions does he have to make tonight?
Excuse me?
What decisions does your client have to make tonight?
You have to make a decision what we ask for, and the judge has a lot of latitude of what he can do.
When you're here at the posse per se, I was running my own law firm. I was working with I just slipped my mind. What did you think about that?
You were surprised.
Nico, this is a first of its kind trial. You said this is the first time this has ever happened to you in your law experience. How do you go about just even figuring out what your next step is? Because this is something that everybody seemed to be caught completely off guard.
We have to make decisions that are in the best interest of our client. We have to do it legally and ethically, and that's what we're going to do tonight. We have to weigh out our options. We have to present them to our client. We have to talk as a team, Gary, ourselves, or Fairlegal. We're going to make a decision. I'm going to pray about it, and then we'll make a decision tomorrow, and we'll make arguments to the judge.
Just legally, what are the other remedies?
The judge can admonish them to excluding evidence, to be creative with a remedy in this trial. There's a lot. The law gives them a lot of latitude.
So ultimately, it also
that's all. So we have to make a request first, and then the judge will make a decision on the request.
What's the significance
Thank you,
of this? Because this is a very unique trial already. So the significance of this issue, of this kind of issue, such a trial.
Well, the issue affects this case, and it affects the credibility of a witness potentially, and then you don't get a second chance at this. We can't rewind. So either we ask for an extreme remedy, the judge either grants or doesn't, or we don't, and then we don't know what the result's going to be. So it's a big deal. You have to make the right decision.
Do you think we could figure out an answer tomorrow?
We as in her.
As in the judge, the prosecution?
Well, we'll make our arguments, and the judge will decide when and what he'll decide. He's not going to say waste any time. He's an experienced jurist. Thanks, guys.
He's an experienced jurist. How the fuck do you know that, bro?
Thank you. I have paid You buy it again? I don't know.
Most horrific. All of us feel for them.
Okay, there's two reasons that I'm showing this. Number one is because I tried to go down there, right? And they say it's open to the public. It's basically fucking not, dude. Unless you're a member of the public that knows some people in high places and you don't wear any metal on your body at all or don't have any screws in your bones or anything like that, and you can walk through a metal detector, butt naked or whatever and not go off. I don't know. Anyways, the whole point is this was supposed to be happening at a certain time, right? And of course, they're not inside, so you can't see any clocks or anything. You don't really know what time it is. And I don't know if you guys know anything about videography, but I've been around cameras my whole life. And a lens filter can do a lot as far as allowing certain colors of light to get in, but also it can change what time of day it looks like whenever the sun's going down, right? So anyways, I just want you to see that this is a continuous shot, and I just want you to see how it can turn from like 6 p.m. to 4 p.m. with the flick of a switch, you know what I mean? So, and the reason I bring this up is because, like in the Judge Boyd case, I think the reason that they did and kicked her off is because of the live stream, right? Anyway.
And this has changed our lives. I've been through a lot personally and professionally, and I've seen a lot of things. And
holy shit, suddenly it's 2 hours earlier in the day, you know what I mean? Like, and see, the whole thing about this is there's none of us there. There's no buddy that's on. Everybody that's there is legacy news media, you know what I'm saying? Like, how did they do that, right? I mean, this is out in the open. Like, there's nobody in the parking lot. Like, this is prime time for fucking somebody to come up and ask him an actual question, you know what I mean? But there was nobody there to do that, and I left. They frustrated the hell out of me. I left way before this.
I feel for them.
So in a nutshell, we kind of arrived late. What happened? What actually happened?
We have a witness that testified.
And then, see, he specifically leaves the part in where he says, we arrived late. But it's my contention that they didn't arrive late. It's just that they let out hours earlier and then did all these interviews. And then by the time people were supposed to arrive when they thought it was over with, it was already too late. You know what I mean? So it's just... They cannot do this shit live and in public anymore. It is impossible for them to have a fucking public trial and have live video feeds of it. It's impossible, dude. They just can't. They can't get away with it. They won't do it unless they can manipulate every part of it, including the time it happens, right? They just can't be honest, dude. That's all I'm saying. And anyways, these two obviously had something to do with the 3 San Antonio police officers, right? Now, the only thing missing is the judge, right? I mean, did the judge appoint this judge? Or did he decide to just be the judge himself, right?
Once again, we're outside the presence of the jury, and I've given counsel an opportunity to confer on potential remedies in regard to the witness. So, what do y'all have?
Well, well, well. The very same judge that took Stephanie Boyd off the case and gave it to the other judge so those cops could get found not guilty, right? He decides that it's upon him to be the presiding judge over this case, but there's one problem with that. He has no jurisdiction or authority to preside over this case, according to the governor.
To report.
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
yeah,
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we
determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy, or in emotional impact, we would add that, and we do believe that under our 403 motion and motion of limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance. Because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children, are the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? I'll make it up.
Yeah, and I guess yes. I think just the court understanding willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now, and like she just goes away, is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Yeah. Right. You see what I mean? And so what it does is it puts us in a situation where that remedy could actually harm.
How does that?
And disclose us.
And then how did that affect your side?
Well, I'm not going to tell you our trial strategy. I'm just saying that the issue is where this shooter allegedly was and what our client allegedly saw. And when he saw this, if he did see it at all, it is a big deal. It's an issue of the case.
And like you said, because this is a first of its trial case.
All right, I want to get this out before the sun comes up, and the sun's about to be up, but I want to leave you with one last thing. Let's say that I'm wrong, and all these people are acting in good faith, and they're trying to do this right and everything right? Let's say that's the truth, right? This judge should still not be presiding over this case. Judge, San Antonio, Texas, Honorable Judge Sid Harrell, presiding judge. This state is divided into 11 administrative judicial regions. The office of the 4th Administrative Judicial Region, 4th is located in San Antonio, Texas, and the 4th AJR was created by the legislature in 1927 and currently covers 22 counties listed below. Presiding Judge Sid Harrell was appointed by the governor in August 2017. The duties of the presiding judge include promulgating and implementing regional rules of administration, advising local judges on judicial management, recommending changes to the Supreme Court of the improvement of judicial administration, and acting for the local administrative judges in their absence. The presiding judge also has the authority to assign visiting judges to hold court when necessary. to dispose of accumulated business in the region, right? And then there's all these counties, right? Okay, the county that we're in, the county that this case is being held in, is Nueces County. It's, as you see, Nueces County is not on that list, but there is a part here where it says that he can blah 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 for the improvements of judicial administration and acting. He can act for local administrative judges in their absence, right? Local judges. I don't know what your definition of local is, but Corpus Christi is 143 miles away from where he lives, San Antonio. So it's definitely not local. And the county that he's in isn't even on the list of counties he's allowed to preside over cases for. And on top of that, even if those things were true and he was allowed to be there, that would mean somebody that was supposed to preside over this case had something happen to where they couldn't, because so he could fill in for them. So it just, it's such bullshit. He's not up there accidentally, right? This wasn't like some mistake, right? This was choreographed and specifically made to be the way it is, dude. Anyways, I gotta save this and whatever so I can put it on YouTube. But I got way more to say, and I'm making another video. But I'd like to ask the legislature or the governor or whoever, what does it mean? What good does it do to elect judges if you can just appoint one and put them over top of those judges and have him move them around to wherever you want, right? There's no point in having elected judges if you can do that. Like, you have to follow the rules, man. Assuming that the rules that you made up and all the counties that you gave, assuming even those are true, it's still, you cannot have this judge in this county judging anybody, right? You need to follow your own fucking rules, bro.